Again, before the enactment of family code, the civil code provided limitations on when husband or wife may deal with conjugal partnership property. Under the family code, the common provisions apply equally to both spouses. Okay? So under Article 73, to be more particular, Article 73 of the family code, either spouse may exercise legitimate profession. Yes. Business or activity without the consent of the other. That's a general rule. But the other party or the other spouse may object on the ground of valid. The ground should be valid, serious, and moral grounds. That is. So what if there is an objection, or in case of disagreement? The courts shall decide whether the objection is proper. So however, if the benefits accrued to the family prior to objection, it means to say a spouse contracted a business or engaged in a business, then prior to the objection of the other party, there is benefit accrued to the family. It means to say from the fruit of business, it provides for the family. Then subsequently there is an objection. So it means to say the resulting objection shall be enforced against the community property. So it means to say expenses in engaging activity of business shall be subtracted or shall be enforced, or any obligation from engaging a business shall be enforced against the community property. So in other words, whatever expenses may incurred in engaging a business, it shall be charged against the community property. So money will be taken from the community property. That is, again, if there is benefit, if the activity or if the business engaged by one spouse without the consent of the other spouse, but such benefit contributes to the business contributes to the benefit of the family, therefore whatever expenses or obligations shall be taken against the community property. Expenses or money for business, to run a business, shall be taken from the community property. What if there is no benefit to the community property, or what if there is no benefit to the family, in which a spouse contracted a business, engaged into a business, but there is no benefit contributed to the family, it cannot provide for the family, the obligations, the expenses shall be charged. From whom? Against the separate property of the spouse who has not obtained consent of the other spouse. Let's make a scenario. Example, A and B are married. A contracted a business without the consent B. So from the business of A, there is benefit. There are benefit obtained from the business. So therefore, whatever the expenses or obligations in running that business, in engaging that business, it shall be charged, or monies or expenses shall be taken against or from the community property. What if there is no benefit from what if there is no benefit obtained from the business engaged by A? So therefore, the expenses or obligations shall be obtained or shall be taken against the property or the separate property of A, only from the separate property of A, not to the community property of the family. It's because such spouse, because A has not obtained consent from B. Due to the effects of Republic Act 6809, lowering the age of majority to 18 years old, RA, this is RA 6809, lowering of age majority to 18 years old. Article 4 is deemed to provide only two qualifications necessary to be a merchant. First is 18 years of age or over and having predisposal of property. The other two requirements of not being subject to parental authority or to marital authority under paragraph number 2 are deemed repealed because a person 21 years of age no longer subject to parental authority. So it means to say below 21 years old and 18 years old above, 18 years old and above shall be subject to parental authority. But if a person is already 21 and above, 21 years old and above, no longer needing for a parental authority. So again, if a person is 18 years old or over but not exceeding 21 years old, there is a need of parental authority. But over 21, there is a need of parental authority. Next, under Article 15, the law that determines the capacity of aliens. The law that determines the capacity of aliens to engage in commerce, whether natural or juridical. So, whether a true human or a human being, natural or juridical person, granted, created under the laws, shall be their national law. Which shall govern their capacity to contract. On the other hand, the Code of Commerce shall govern the creation of their establishment in the Philippines, their mercantile operation, the jurisdiction of Philippine courts. In special cases, governed by treaties, yes, governed by treaties, because they are already a foreign. Philippines are already engaging commerce, so relationship with or interrelationship with other countries. The provisions of said treaties shall prevail. So again, when it comes to the capacity to contract, of a foreign investor or foreign entity, the capacity to contract shall be subject to their foreign law, to their law. But when it comes to the creation of their business or establishment here in the Philippines, the mercantile operation, the operation shall be subject already to the Code of Commerce. But also, let us not forget those special cases governed by treaties. Next, when it comes to general application to foreign corporations, Article 15 is deemed to have been superseded by Section 68 of the Corporation Law. When it comes with general application to foreign corporations, so it shall be already subject to corporation law. Now, Section 129 of the Corporation Code. Our Corporation Code is already revised last 2018. 2018 or 2019, either of that, it's already revised Corporation Code. But here, Section 29, any foreign corporation lawfully doing business, that is in Section 29, lawfully doing business in the Philippines shall be bound by all laws, all be bound. So it means to say any foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules, on regulations applicable to domestic corporations of the same class, save and except such as only save and except. What's that? Such only as provided for the creation, formation, organization, or dissolution of corporations, such as fix the relations, liabilities, responsibilities, or duties of stockholders, members, or officers of corporations to each other and to the corporation. But how is that? It means to say any foreign corporation lawfully doing business in the Philippines shall be bound by all laws. Shall be bound by all laws, but except save and except. It means to say save and except, it shall include the creation, the formation, um, save and except the creation, organization, dissolution of corporations such as fixed relations. So that's an exemption already. Exemption. That's an exemption already. Again, foreign entities are subject to laws here in the Philippines. All laws, rules, and regulations applicable to domestic corporations of the same class. So it means to say, if that foreign corporation doing business in telecom, so all those corporations, whether foreign or domestic, shall be governed by the same law governing telecom companies, except the creation, formation, organization, or dissolution of corporations, which is already subject to their foreign countries, subject already to their foreign laws. That's Article 15, which is correlated with Section 29 of the Corporation Code. Next, Article 2, Acts of Commerce, whether those who execute them be merchants or not, and whether specified in this code or not. And whether specified in this code or not, should be governed by the provisions contained in it in their absence, by the usages of commerce generally observed in each place, and in the absence of both rules, by those of civil law. Those acts contained in this code and all others of analogous character shall be deemed acts of commerce. How? What's that? Article 2, acts of commerce. Those are acts of commerce. Acts of commerce, whether those who execute them be merchants or not, whether specified in this code or not, should be governed by the provisions contained in it. In their absence, by the usages of commerce generally observed in each place, and the absence of both rules, by those of civil law. So it means to say, all those acts of commerce shall be governed by the Code of Commerce. Again, all acts, all actions of commerce, doing business, shall be governed by the Code of Commerce. What if Code of Commerce is not present or is absent? Those usages of commerce generally observed in each place. Customs. What if there is no customs, or there is no generally observed rules on that place? So civil law shall apply to any acts of commerce. Article 50, commercial contracts in everything relative to the requisites, modifications, exemptions, interpretations, extinction, and to the capacity of their contracting parties shall be governed in all matters not expressly provided for in this code or in special laws by the general rules of civil law. How is that? The Article 50 The articles provide the hierarchical applicability of laws to commercial transactions such as follows. First, the Code of Commerce. Second, it's the commercial customs in the absence of first. So this is now Article 2. This is now the Article 2, elaborating Article 2. Okay? The very first applicable laws for commercial acts, commercial transactions, is the Code of Commerce. What if Code of Commerce is not present? Therefore, commercial transactions, commercial customs. But first, Code of Commerce. Next, what if there is no customs? Therefore, the Civil Code. In the absence of the above two. Article 2 of the Code of Commerce has lately been invoked in Transfield Philippines Incorporation versus Luzon Hydro Corp. to justify application of Philippine jurisdiction of the Uniform Customs and Practice for documentary credits to matters relating to letters of credit. So, it means to say, this hierarchy of applicability of laws were applied in the case of Transfield in determining to justify the application in Philippine jurisdiction of Uniform Customs and Practice for documentary credits. How about Article 50? It was not explained here. Again, commercial contracts in everything, commercial contract in everything relative to the requisites, modifications, exemptions, interpretations, extinction, and to the capacity of their contracting parties, like obligations, shall be governed in all matters not expressly provided for in this code or in special laws by the general rules of civil law. So it means to say commercial contracts shall be governed by obligations and contracts. In the absence, if shall be governed in all matters not expressly provided for in this code. So it means to say provisions relating to requisites, modifications, exemptions, interpretations, and extinction, and to the capacity of their contracting parties shall be governed by this code. What if there is no provisions stating governing those requisites, modifications of contracts? What if those are not absent? What if those are absent in the Code of Commerce? So therefore, it is now the civil law, particularly the obligations and contracts provisions.